Is in-session law enforcement analyst and contributor Mike Brooks and criminal defense attorney and former prosecutor Rene Sandler. Thank you both for joining me. Rene Sandler, I want to start with you. I don't know if you had a chance to listen to Ethan Chic-Colbert's statement to the court, but after he made his statement, Judge Bloom then asked him a series of questions. And I was wondering if that's your experience, that the judges will actually engage a defendant in questioning, like, what were you thinking, what were you doing, you're making yourself a victim here. Well, I don't find that too common, do you?
No, very, very uncommon. But whereas in this case you have a defendant who really has exhibited little, if any, remorse whatsoever and was just found guilty by a jury of causing the death. You know, that was part of the child neglect statute, that he had to be shown to have caused the death, and stands there before the judge who is about to pass sentence and denies responsibility. So I think it's fair game for a judge, and a defendant certainly should be prepared to answer such questions.
Now, do you think that perhaps his attorney cautioned him about certain things he should say or not say in the event this case is, well, in the event the case is reversed and retried? Could anything he said now be used at a new trial?
Very possibly, and it's a very tight line that a defense attorney must walk with his or her client to explain how statements made can then be used later should the case be reversed. And you need to be careful. But I will say this, there is an appropriate balance that absolutely can be taken to show the appropriate level of remorse and accept responsibility in ways that cannot be used against him should the case come back. And that's preparation by a defense attorney.
But Rene and Beth, when you have a judge ask someone after they gave their statement if they were trying to intimidate someone by those telephone calls, that's not a good statement from the judge to the defendant by any stretch of the imagination.
Yeah, it doesn't bode well. Well, Mike, let me ask you, victim impact statements are typically given right before the sentence. And I mean, I'd like to think that the judge has thought about the sentence before hearing these victim impact statements. So what effect do you think they have on the judge?
Well, you know, talking to a number of different judges, you know, on different cases we work, Beth, most of the time they do already have in mind at least a range that they're going to go with. But you never know the emotion that's going to come out in that courtroom before you, and sometimes the judges do decide right then and there exactly what he is going to give the defendant. You know, in this particular case, we're hearing about his gang activity, all his tattoos, that detective who was with the intelligence division of the Charleston, West Virginia. I thought that was really damaging evidence for this particular sentencing here. It was just, it's not looking good for him right now.
Rene, let me ask you a question about victim impact statements in general. I know that in the last decade, several states have passed Victims' Bill of Rights, and they recognize and have actually passed legislation to allow for victims' family members to make these statements before the court. Now, they talk about things that they can't say on the witness stand, or things about their lives of the victim that aren't admissible at the trial itself. But why is it important for these statements to become part of the record?
Because the rules of evidence which govern what comes in before a jury are very strict, and so what may be admissible in a court is I should say what is inadmissible in court is admissible in sentencing, because a judge needs to understand who this person is, and the totality of experiences with the victim is directly relevant. For example, the history of domestic violence. And the victim impact statement is an incredible tool for the judge to hear firsthand how, in fact, their lives are forever changed. So it's an important tool for the judge.
And who is generally allowed? You know, when you have a decedent, you have a person who's died, who's generally allowed to give these?
In a case such as this, it would be the mother, you know, the immediate family. In some cases, and murder cases, for example, where I've tried cases, we've had to limit and file motions to limit who can address the court. It's typically someone directly impacted, a mother, a sister, a brother, a teacher, perhaps, that can speak firsthand about a victim, but also come forward and talk about experiences with the defendant. But somebody with a very close relationship and direct personal knowledge of matters of importance to the judge.
Now, I know that you've done work with domestic violence, child abuse, and I just wanted your thoughts about whether or not child abuse laws take into account the type of abuse in this case. That is, a man beating on a mother and the child witnessing it. I mean, that's hard on the child, and that affects the child. And I mean, does the law take that into account as a type of abuse? And if not, what should be done about it?
Well, that's a great topic for an entire show, because the effects of child abuse and domestic violence on children is just incredible. It's lifelong, it's traumatic. In a sentencing, just back to what we were speaking about before, the history of domestic violence, what Jaleel had experienced in his life in terms of the effects and witnessing domestic violence, all becomes relevant in a victim impact statement. But laws do need to change. One of the problems here with the kidnapping and child abuse per se is not an enumerated felony for felony murder. Laws need to be looked at and addressed in terms of the seriousness of child neglect cases and the penalties. Generally, the penalties for child neglect are not terribly significant. And perhaps we need to address those laws as a nation to protect children.
And Mike Brooks, finally, almost out of time, I want to ask you about Chic-Colbert's statement. You know, he did get upset. He was emotional. He talked about reading books while he's been incarcerated. He wants to do something good with his life. He wants to share his story. I mean, it's easy to say, just lock him up, throw the key away, and forget about him. But, you know, I mean, were you moved by what he had to say? Because maybe it's true. Maybe he really has had you know, sort of a change while he's been incarcerated.
He hadn't been in that long, so I doubt if there's been that much of a change. But the bottom line is here, Beth, he still accepts zero responsibility for his actions, and I think that is what the judge was able to see through all the you know, his little catharsis that he may have had. But the bottom line is he still accepts no responsibility.
Well, thanks for your contribution. The two of you don't go away. Before we get to the defendant's sentencing, we'll have one more impact statement from the mother of the victim's best friend.